Oh no, we're upside down. I can't switch it. God damn it. God damn it, Bobby. We'll do it live. Oh well, you're gonna have a bad image. As if seeing my pretty face would make things better. While people are filtering in, if people are filtering in, who knows, who cares? Earl, so the Court of Appeals in Earl Warden's case, is this 2:29 start time Eastern or Pacific? Yes. Yes, one of the two. You decide. So in Earl's appeal, the Court of Appeals decided to actually allow the opposition to be filed. So the state's opposition is going to be considered by the Court of Appeals. I don't think it is going to change anything. Is this really muted? Well, so it doesn't show muted on my end, but I don't know. Am I retarded? Maybe. Thank you, Paul. All right, so I just got so excited. I ate my lunch, and I'm like, you know what I'm going to do? I'm going to cover the order to show cause in the Springer versus the 7th Judicial District Court, because I was screaming forever into the void about the retards who were fighting the plaintiff's attorney is a retard, or at least his filings have been retarded. The defense attorney is a retard, or at least her filings have been retarded. This order to show cause is so refreshing, because I was screaming about judicial immunity and about other issues in this case, and they were ignoring it. Well, the defense was ignoring it, and I guess the plaintiff's attorney has no cause to raise it if the defense hasn't broached the subject. But thank Christ that the judge was like, you know what would be great? It would be great if we didn't waste everybody's time, and you told me that this actually was going to be able to stand and not get overturned or something because of these issues. So this matters before the court on a sua sponte review of the record. That just means the court decided on its own, without a motion from either party, to go on the record. For the reasons that follow, plaintiff shall have 21 days from this date of from the date of this order to show cause why his claim should not be dismissed. Background. According to the second amended complaint, on February 28th, 2023, the Chief Judge of the 7th Judicial District Court, Defendant Mercedes C. Murphy, Chief Judge Murphy, issued an administrative order that, in the interest of safety and security of the judges, special commissioners, hearing officers, and other court personnel, barring plaintiff from entering the Torrance County District Courthouse in Estancia, New Mexico, unless appearing for a hearing or having a specific court business, in which cases plaintiff shall be escorted and accompanied by the Torrance County Sheriff Office while in the building. That's footnote 1. The administrative order is attached as Exhibit 1 to the second amended complaint. On March 1, 2023, 2 officers with the New Mexico State Police delivered a copy of the administrative order to plaintiff. So that's interesting. So that's interesting. The court found that, or it was alleged at least by somebody, that ECF 99-1 administrative order. ECF 99, that is the second amended complaint. So Springer alleges that he was served with this administrative order. I thought he said he hadn't been served. I thought he didn't have notice and opportunity. So that's interesting, right? At the same time, the officers delivered to plaintiff a copy of a letter dated March 1, 2023, to plaintiff and defendant Jason Jones, the court executive officer for the 7th Judicial District Court. The letter states, as CEO of the 7th Judicial District Court, it has been brought to my attention the court staff are being harassed on your behalf and has impacted court resources. The court has issued an administrative order on March 1, 2023, that if you are required to be in court or have official court business, you will check in with the Torrance County Sheriff's Office to be escorted and accompanied pursuant to the administrative order. That's the March 1st letter. That's attached as Exhibit 2 to the second amended complaint. On March 23rd, 2023, Chief Judge Murphy entered an amended administrative order barring plaintiff from entering other courthouses within the 7th Judicial District unless appearing for a hearing or having specific court business, in which cases plaintiff shall be escorted and accompanied by the law enforcement while in any of the buildings. It is dusty. I don't care. You want to come and wipe it off? You're supposed to be looking at my beautiful face, not my my panel. My instrument panel. And that is footnote 3. It's attached as Exhibit 3. Okay, on the same day, Defendant Jones signed a second letter to plaintiff, saying the defendant entered the Moriarty Magistrate Court for non-court business and was, quote, disruptive and threatening in the courthouse. That's footnote 4, the March 3rd letter, Exhibit 4. The March 23rd letter advises plaintiff that Chief Judge Murphy amended the administrative order to require that plaintiff be escorted and accompanied in any of the 7th Judicial District's magistrate or district courthouses. On May 18th, 2023, plaintiff attempted to attend a public hearing, quote, as a member of the press to report on the case in a criminal matter before the Honorable Mercedes Murphy by way of a video conferencing platform. After dialing in to the public hearing via the video conferencing platform, Judge Murphy summarily ejected plaintiff from the video conferencing platform and from the public hearing without providing plaintiff notice and an opportunity to be heard on the matter of whether he could attend the public hearing. On May 24, 2023, Judge Shannon Murdoch-Poff issued an order excluding plaintiff from a hearing in a civil matter that plaintiff planned to attend as a member of the press and the public. And that's footnote 5. Order excluding presence is attached as Exhibit 5. The Second Amendment complaint alleges that on multiple dates, Susan Rosengal has either refused plaintiff's statutory right under New Mexico law to petition his government for redress by inspecting public records in the clerk's office. That's footnote 6. Second Amendment complaint alleges that defendant Rosengal is a clerk of the 7th Judicial District Court of New Mexico. It alleges that defendant Rosengal, out of retaliation, has required state police presence to harass and intimidate plaintiff when he entered Estancia District Courthouse for the purpose of conducting court business associated to making court records. This retaliation accumulated an outright refusal to accept protected petitioning activity to exercise the statutory right to request public records on June 8, 2023, and Ms. Rosengal requiring the Torrance County Sheriff's Deputy Young chase plaintiff from the building, which he did. And that's citing to the footnote 7. Footnote 7 is the Second Amendment complaint contains 2 paragraphs numbered 30. The court citation to paragraph 30 and then in parens 1 refers to the first paragraph 30 sequentially. You don't need to put likes in. I don't fucking care. I mean, if you want to, you can. If you don't, I just don't care. On February 21, 2024, plaintiff filed the operative Second Amendment complaint asserting 4 causes of action. Count 1 alleges a claim under 42 U.S.C. 1983, predicated on violations of First Amendment rights, freedom of speech and press, which plaintiff characterizes as, quote, viewpoint discrimination, end quote, against Chief Judge Murphy and Judge Murdoch-Poff. Specifically alleges that Murphy and Poff engaged in viewpoint discrimination by banning and excluding plaintiff from a public places, that's with a SIC, meaning that that is the way it was in the original, and hearings prohibiting him from attending and reporting on public matters. And then this, that was 31 bracket 2, and then footnote 10. Oh, we missed a couple other footnotes. So footnote 8 was the Second Amendment complaint contains 2 paragraphs numbered 35. And then 35 bracket 1 refers to the first paragraph 35 sequentially. Count 1 of the Second Amendment complaint contains 5 paragraphs numbered 36, 30, 31, 32, and 37 in that order. The general allegations also contains paragraphs numbered 30, 31, and 32, which are different than the paragraphs numbered 30, 31, and 32 in count 1. And then footnote 10 says the Second Amendment complaint contains 2 paragraphs numbered 31. The court citation to 31 parens 2 refers to the second paragraph 31 sequentially. So the court was also noticing how slapdash the complaint was. Count 2 alleges a claim under 42 U.S.C. 1983 predicated on retaliation in violation of First Amendment rights to the freedom of speech and press, including denial of the protected liberty interest in petitioning the government against all defendants. Specifically, it alleges that defendants Jason Jones and Susan Rossignol have each undertaken a retaliatory effort, and then in parentheses, Jones to issue threatening letters designed to chill plaintiffs' exercise of speech, press, and petition, and Rossignol to refuse plaintiff's statutory right to inspect public records, to give false reports to state police about plaintiff being an armed threat endangering his life, and cutting off his ability to petition his government by closing the government office during normal business hours when plaintiff was present. End parens. Upon information, all retaliatory efforts, including excluding plaintiff from defendant Murdoch Poff's public hearing, were undertaken at the direction and in agreement with defendant Murphy. Count 3 alleges a claim under 42 U.S.C. 1983 predicated on procedural due process violations, apparently against all 4 individual defendants. Specifically, it alleges that the orders issued by defendants Murphy and Poff and the actions taken by Jones and Rossignol deprived plaintiff of his fundamental liberty interests in speech, press, and petitioning without due process of law, based solely upon discretion of the defendants. Count 4 alleges a violation of Article 2, Section 17, 18, and 23 of the New Mexico Constitution against defendants 7th Judicial District Court only. It alleges that the 7th Judicial District Court violated plaintiff's constitutional rights of freedom of speech, freedom of press, freedom of assembly, and due process when it entered the amended administrative order, and Judge Poff's order excluding presence, when it had those orders and defendant's letters served on plaintiff with no notice and no opportunity to be heard. Generally speaking, when you have an order served on you, that's your notice, and it'll say when and how you could challenge it. Or you can seek a writ of mandamus or a writ of prohibition, or you can file an appeal or something like that. You got lots of options. You don't have to sue under 1983. It further alleges that the 7th Judicial District Court violated plaintiff's right to free speech under Article 2, Section 17, when it retaliated against plaintiff by ejecting him from the public hearing on May 18, 2023, by denying him access as member, and then that's a statement in the original, SIC, or as stated in the original, SIC, of the press to defendant Murdoch Poff's public hearing, denying him statutory rights to access public records, and harassing with unnecessary and chilling law enforcement presence. The second amended complaint is asserted against the individual defendants in their individual capacities only. Counts 1, 2, and 3 seek declaratory and injunctive relief only, while count 4 seeks damages from the 7th Judicial District Court. On March 6, defendants filed a motion to dismiss, arguing the second amended complaint should be dismissed for a failure to state a claim. Plaintiff filed a response, to which defendants filed a reply. That motion remains pending. So the court's like, you fucking idiots. Like, why didn't you deal with this shit correctly? Now I have to step in because you're fucking dumb. Discussion. Defendant's motion to dismiss does not assert judicial immunity, quasi-judicial immunity, or 11th Amendment immunity as a basis for dismissal. And then footnote 11, although count 1 of the second amended complaint alleges that Judge Murphy and Judge Murdoch Poff do not enjoy judicial immunity here for their administrative orders, this is a legal conclusion and is not entitled to a presumption of truth at the pleading stage. He tried to pull a chili. However, the court raises these issues sua sponte. Again, sua sponte means on its own, because it appears the defendants may be immune. And then there's citations. Even if the defendants are not immune, it appears that counts 1, 2, and 3 fail to state a claim under Section 1983. And again, the cause of action against number 4, the cause of action against the Judicial District Court, the 7th Judicial District Court itself, is there. Well, I don't know why it's there, because that's the only cause of action against them. There's no 1983 cause of action against them. So I don't know why or how they're there. I mean, that's the only cause of action against them that's alleged in the complaint, and it's a state cause of action. So I don't know how that's so. Like, you could sue someone in federal court on a federal cause of action, and then you could like tag on some state causes of action without any issues, generally speaking. And the district court will have the power to hear those state issues because, well, we're just going to resolve all the claims between these parties at the same time. There is no federal cause of action against the 7th Judicial District Court. So I don't know how they get there. And also, like the 11th Amendment is the amendment that says that you can't sue a state in federal court unless essentially Congress has granted some sort of a cause of action to you to allow you to sue the state. You can't sue the state. Well, I don't even know if you can do it if Congress gives you a cause of action, but that would be interesting if it did. But like 1983 doesn't allow you to sue the state. You could sue subdivisions like cities. You can sue cities under Monell theory of liability, failure to train, etc. But you can't sue the state under a 1983 cause of action, I don't believe. And I think if I remember correctly, the rationale behind that is the 11th Amendment prohibits it. But it doesn't prohibit it against a city because that's not a state. Although that seems like a really fine distinction to make. I'd have to think about it some more and not be sitting in a parking lot on my lunch break. All right, so absolute immunity and quasi-judicial immunity. Judges of courts of superior or general jurisdiction are not liable to civil actions for their judicial acts, even when such acts are in excess of their jurisdiction and are alleged to have been done maliciously or corruptly. And then there's a footnote. 12, similarly in New Mexico, judges have absolute judicial immunity from liability for their actions taken in performance of their roles as integral parts of the judicial process. To determine whether a defendant enjoys absolute judicial immunity, the court applies a functional test to determine whether the acts alleged by plaintiff were judicial functions. Back up into the document, citation. Indeed, a judge is absolutely immune from liability for his judicial acts, even if his exercise of authority is flawed by the commission of grave procedural errors. Furthermore, by enacting the 1996 Federal Courts Improvement Act, enjoy some leaf blowing, by the way, folks. Consider this to be your ASMR experience. Furthermore, by enacting the 1996 Federal Courts Improvement Act, Congress expanded the ambit of judicial immunity by amending 1983 so as to provide injunctive relief against a judicial officer. Citation, 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 citation. The Supreme Court has stated the factors determining whether an act by a judge is a judicial one relate to the nature of the act itself, i.e. whether it is a function normally performed by a judge, and to the expectation of the parties, i.e. whether they dealt with the judge in his judicial capacity. However, the Supreme Court has never undertaken to articulate a precise and general definition of the class of acts entitled to immunity. Instead, it has explained that immunity is justified and defined by the functions it protects and serves, not by the person to whom it attaches. Like other forms of official immunity, judicial immunity is an immunity from suit, not just an ultimate assessment of damages. So it can be raised early. Accordingly, judicial immunity is not overcome by allegations of bad faith or malice, the existence of which ordinarily cannot be resolved without engaging in discovery and eventual trial. Rather, judicial immunity is overcome in only two circumstances. First, a judge is not immune from liability for non-judicial actions, i.e. actions not taken in the judge's judicial capacity. Second, a judge is not immune for actions, though judicial in nature, taken in the complete absence of all jurisdiction. Just as judges acting in their judicial capacity are absolutely immune from liability under Section 1983, officials charged with the duty of executing a facially valid court order enjoy absolute immunity from liability for damages in a suit challenging conduct prescribed by that order. Citation, citation, citation. Additionally, absolute judicial immunity has been extended to non-judicial officers where their duties had an integral relationship with the judicial process. Citation, citation, citation. Like judicial immunity, quasi-judicial immunity is absolute immunity from suit. Citation, citation, citation. Here, it appears that counts 1 through 4 are all predicated on the issuance and execution of, number 1, Chief Judge Murphy's administrative order barring plaintiff from entering the Torrance County Courthouse in Estancia, New Mexico, unless appearing for a hearing or having specific court business. 2, Chief Judge Murphy's amended administrative order barring plaintiff from all of the seven judicial districts, magistrate and district courthouses, unless appearing for a hearing or having specific court business. 3, Chief Judge Murphy's decision to remove plaintiff from a hearing being held virtually via video conference. And 4, Judge Murdoch Poff's order excluding plaintiff's presence at a hearing in a civil matter. Because issuing administrative orders is a function normally performed by a chief judge, citation, to a non-published case, by the way, it's this Reynolds versus Flynn, not published. Somebody tell Eline, this judge is going to get left out of court. Because issuing administrative orders is a function normally performed by a chief judge, it is a judicial act to which judicial immunity applies. And to be sure, judicial control over who may appear before a judge is inherently a judicial act, not an administrative one. Citation. As such, an order or other act barring an individual from entering the courthouse or courtroom is a judicial act to which judicial immunity applies. Oof. Citation. Lots of citations backing that particular claim. Because of all of plaintiff's claims appear to be predicated on judicial acts to which judicial and quasi-judicial immunity apply, plaintiff shall, in bold caps, show cause as why the second amended complaint should not be dismissed for failure to state a claim. Oof. 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 11th Amendment immunity. The 11th Amendment states the judicial power of the United States shall not be construed to extend in any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subject of any foreign state. The 11th Amendment bars suits in federal court against a non-consenting state brought by the state's own citizens. Citations. This immunity extends to arms of the state and to state officials who are sued for damages in their official capacities. Citations. 11th Amendment immunity constitutes a bar to the exercise of federal subject matter jurisdiction. Citation. Thus, a plaintiff may not sue a government entity or its employees for a damage claim arising out of violation of rights under the New Mexico Constitution unless the New Mexico Tort Claims Act constitutes a waiver of liability. Citations. More citations. Thus, if no specific waiver can be found, Thus, if no specific waiver can be found in the New Mexico Tort Claims Act, a plaintiff's complaint against the government entity or its employees must be dismissed. More citations. In count 4, plaintiff has asserted a claim for damages against a governmental entity rising out of violations under the New Mexico Constitution. As such, it appears that count 4 is barred by sovereign immunity. Citations. Accordingly, plaintiff shall show cause why count 4 should not be dismissed for lack of subject matter jurisdiction as barred by the 11th Amendment. Citations. Oof. Freeman, do you hear this shit? Bro, oof. This judge is going to eat your fucking lunch, bro. Oof. Ouch. Individual capacity suits under Section 1983. This is Section C. Section 1983 plaintiffs may sue individual capacity plaintiffs only for money damages, and official capacity defendants. Section 1983 plaintiffs may sue individual capacity defendants only for money damages, and official capacity defendants only for injunctive relief. Here, plaintiff is attempting to sue individual defendants in their individual capacities for injunctive relief only. Accordingly, assuming arguendo that they're not immune. Oh, there's layers of why you're losing on this, Freeman. Literal layers of it. Plaintiff shall show cause why counts 1, 2, and 3 should not be dismissed for failure to state a claim. Citations, 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 citations. Therefore, it is hereby ordered that plaintiff shall have 21 days from the date of this order to show cause why the claims asserted in the second amended complaint should not be dismissed for failure to state a claim and or lack of subject matter jurisdiction. And 2, defendant shall have 14 days from the date plaintiff files his response to this order within which to file a reply. Oof. What that means is that Springer loses. James Freeman has lost. In theory, there is a chance that his attorney can pull some magic fucking rabbit out of his ass and find some grounds to pursue this. But there was a reason why I was screaming at my monitor in my backyard, disturbing my chickens, shouting about judicial fucking immunity. Oh, I don't remember if I raised the 11th. I raised the 11th Amendment on something. That might have been on a Chile claim. I don't remember. They all blur together. Too many. I was reviewing too many cases where retards were saying retarded shit over and over again. That was a breath of fresh air. That was amazing. That was awesome. Oh, so notice, like, attorneys should write like the courts write. Succinct. Get right to the point. Issue, rule, analysis, conclusion. Issue, rule, analysis, conclusion. Here's the issue. Here's the rule. Here's applying the rule to the facts. Here's your conclusion. Boom, done. There's a reason why they teach it in law school. This judge did it perfectly. You don't need to talk about Thomas Jefferson. You don't need to talk about politics. You don't need to talk about shit. He was trying to sue the state of Nevada as a California resident. Well, even as a resident of the state of Nevada, he still was barred. I raised that before. But anyway, it is refreshing to see a well-written, concise, direct, to the point motion. It's essentially a motion. It's an order to show cause, but it's a motion. It's the court's own motion. So yeah, it's awesome. And James is lost. Like, I'm going to call it now, stick a fork in him. He's done. His attorney's going to shit out some random word salad about Thomas Jefferson or Thomas Paine or fucking who knows? Lysander Spooner, some dumbass shit. He's gonna call, what was that? Brandon Joe Williams, that new solve sit on Chili's channel. Freeman's attorney's gonna call that guy up to shit out some word magic. Oh, it's gonna be terrible. And then after Freeman's attorney shits out some garbage for the court, then the defendant's attorney is going to take all that random, just pure diarrhea shit, churn it up, add some more shit to it, churn it up some more, and then spit it back into the court's face as a reply. It's going to be terrible. And I'm not going to read either one of those because they would just frustrate me. But that was excellent, and Freeman's lost. Thanks for watching. Have a great day. And I don't even know how to end this.